Still no word from Natchitoches on estimates for the certified and signed transcripts.
Not yet. I'll send her. Friendly reminder. This is disappointing.
The Campos trial transcript is available and will prepare cost to you and send soon. All other requests do not have a tray on record. There is no estimate of pages available at this time as those cases are well past appeal delays. If you are requesting a court reporter prepare those transcripts, a $100 deposit for each hearing or trial is required. The preparation of those transcripts will be significantly delayed with an estimated delivery of late next year.
I would get her to explain why preparation of those transcripts will be significantly delayed with an estimated delivery of late next year. I've never heard of such a thing. Making you wait 6 months. That sounds very fishy. She has to give you an adequate reason for such a delay.
Philip, I've pondered this. I'm inclined to think that this is normal. For my initial equestrian for Travis court transcript, her initial time for delivery was 3 to 4 months or something like that. After I told her that that was too long and that the transcript was for purposes of appeal, she shortened the time to 30 to 45 days. When the transcript was delivered, she made a comment on how we all worked very hard to get this done on time. Producing a transcript, for these people, it seems, is very unusual. In her reply she mentions that these cases are past any time for appeal, which I take to mean we are not compelled to produce these within any time frame. So, for the transcripts other than Campos, she is giving herself a month for each of the other transcripts, which is probably about her speed. If a statement from her about why these take so long would be useful, I'd be happy to ask. If so, if you could help me out with some verbiage, that would be greatly appreciated.
From my experience, I found her timeline unusual because court reporters in Caddo Parish District Court and Bossier Parish District Court can generate trial transcripts that run nearly 1,000 pages or within a month or 2 maximum. The same is true for other jurisdictions that I've dealt with. Shanita isn't having to generate transcripts for appeals on a regular basis, so I don't think she stays busy with generating transcripts like district court reporters do. Then again, Shanita is wearing multiple hats, right? Maybe Natchitoches City Court is stretched thin when it comes to personnel. Or maybe she is annoyed by all of these requests. Or paranoid for Owsley's sake. I don't know.
She seems stretched thin based on what we heard when requesting the original transcripts for Travis. I wonder if we are allowed to supply our own licensed court reporter to do the transcripts.
My understanding is that they will not give up the court audio recordings to anyone. I asked them before if I could get them and they said no.
Licensed court reporters have rules and ethics they follow. I wonder if a licensed court reporter might get access where others don't.
These conclusions seem to be established. 1. Shanita Owsley will only do what they are required to do. 2. Even when required to do something, they will fail to meet the requirement if they think they can get away with it. It seems obvious that you are investigating the offices of Owsley Prosecutor Public Defender for their failure to provide attorneys to indigent defendants. I would come right out and state this purpose of investigation, and state that clearly the Law, Public Records Act provides that this investigation is appropriate, and that any failure to provide the public records that enable the private investigation of corrupt public officials is a violation of the Act. To allow corrupt public officials to avoid being held accountable for their corrupt actions by allowing them to delay the production of public records is to negate the Act itself. Shanita's time estimates are unreasonable, for Owsley must be held accountable for his corruption within his own election cycle, and within a time frame that would allow for his censure, reprimand, discipline, and even removal within his current term in office. I would go on to threaten that if the transcripts cannot be provided within a reasonable 60 days, you may institute enforcement proceedings requesting a writ of mandamus be issued, injunctive or declaratory relief, and attorney fees, costs and damages per the Act, and copy Owsley. Then, it's a Mexican standoff. Owsley will reason they'll never find a lawyer to take the case, and will be in the position of raising funds to hire a lawyer to take the case.
I like it. Based on my previous research and whatnot, the lay of the land looks like this. 1. Transcripts are not necessarily public records. They become public records once they are turned over to the court or filed with the court. Until then they are considered a work product of the court recorder, but they are the property of the court. I'm waiting to see what her quote is for the Campos transcripts, since they were already produced. I am not sure if they were actually filed anywhere, but I will take the angle that they are public records. I'm curious to see if she tries to charge transcription fees or public record fees for those. If she tries to charge transcript fees, I'll ask that the estimate be signed by Owsley. I explained this to them in my complaint letter to Owsley. Once filed or turned over to the court, transcripts become public records. As public records, they will be cheap.
I agree with Robert, Daniel. Even though I don't have direct evidence, I feel as if Shanita is stonewalling us in our investigation. 6 months is unreasonable in my opinion given what I've seen happen in other courts throughout this state. I practiced in South Louisiana for years and have been practicing in North Louisiana for years. I've dealt with many different court reporters from all across the state. I've never had one estimate 6 months for a turnaround time. She probably has inferred that you and I are working together. At this point, I say just put down that you are working for me as my investigator and CC me on your email threads with Shanita. How does everyone feel about Daniel being this forward about our relationship at this point? Owsley may freak out if he finds out that I've been spearheading an investigation of him.
Wasn't her estimate a year, not 6 months? She said late next year, which would be late 2023?
You're right. She said late next year. We aren't waiting that damn long. It's time to up the ante with her. Drop a hammer on her.
Perhaps we could first get her on record confirming she means late 2024, otherwise she could say she meant late 2023. And we might inquire to see if there are others they can outsource the transcript to. I certainly am not opposing dropping Phil's name, but let's make sure we get her to double down on her position first so that it's part of the record.
Good idea.
Yeah, good idea, Doug. Her wording was somewhat vague. She could mean one thing, and we think something else.
Shanita, just to make sure that I'm meeting this correctly, are you saying that the preparation of the transcripts will be delayed until late in 2024? The law specifies when requested by a litigant. B. When a transcript is requested by a litigant, the court reporter or deputy court reporter shall be paid in advance and shall furnish such transcript within 30 days of payment. If the court reporter or deputy court reporter is unable to furnish such transcript within 30 days following the request and payment of the same, the court reporter or deputy court reporter may apply for an extension by written request to the trial judge, who may grant the extension for a reasonable period of time for good cause. When a court reporter or deputy court reporter requests an extension, the court shall send a notice or certificate to the litigant who requested the transcript.
How do we link it to Travis' case? There isn't currently active litigation involving the other cases.
For potential ideas, I got online and looked for any cases tied to the statute that Daniel cited. I see no cases referencing the statute in Fast Case. Daniel, did Shanita charge you public records fees for the certified court minutes that we already obtained? If she did, we can argue that she is treating these requests on this representation issue as a public records matter and, by extension, should do the same for the transcripts relating to the court minutes.
It is weird. It has changed a number of times. 1. Minutes are governed by specific statute as well. By statute, they can charge $15 per minute. The first set of minutes she sent for free. Later, When I was going after her for the way that she handled transcripts, she quoted me the $15 per minute, greater than I asked Stamy, and they basically charge public record costs for minutes, greater than. This was something else that I put in my complaint letter to Owsley. Shanita said that she followed what the district court did, greater than. The next minute request she dropped from $15 to $3. The cost has changed every time. I think that these are public records because they are produced as a matter of routine by the court, not by request. Transcripts are produced by request.
Good grief. I don't think any of them know what they are doing. They don't seem to know the law.
Every elected first-time judge should have to take some classes and/or have a mentor judge who reviews what they do, especially if they have spent their entire career in divorce court. I don't think that they much care about the law.
Owsley's Facebook profile picture is literally of Lady Justice with scales. You can't make this stuff up. Shaking my head. One could do a whole YouTube video on the irony.
I asked to confirm the timeline for producing the transcripts. Her reply:
Yes, but there is no requirement to prepare transcripts for a non-party to the case. Therefore, more than likely those transcripts will not be prepared. If you are still interested in the Campos transcripts, a statement depicting the costs for that will be provided.
She has now revealed herself. She is clearly stonewalling us. I have never had a court reporter say there is no requirement to prepare transcripts for a non-party to the case. Therefore, more than likely those transcripts will not be prepared. Be aware that court reporters answer to the judges of their respective districts. Daniel, give me a day or two, and when I get some free time, I'll compose a response to Shanita's letter.
This was my reply to her. Shanita, yes, I'd like to get the estimates for the Campos transcripts. My understanding is that if the Campos trial transcript was filed with the court, it then became a public record. I'd like to have those estimates signed off on by Owsley. Thanks.
Daniel, I would ask her to cite the supporting law for the following assertion from her. Yes, but there is no requirement to prepare transcripts for a non-party to the case. I can find no law in support of her assertion. No law exists that says a court reporter can deny a citizen's transcript request. By her logic, she could deny the press, regular citizens, and anyone else access to the functioning of the courts. There would be no way to monitor what the courts are doing except while cases occurred and only if one were a party in the cases. If her reasoning were correct, the First Amendment would lose most of its meaning since the courts are where most monumental decisions are made about public affairs. This kind of statement indicates her non-transparent mindset and is highly disturbing. Initially, she talked about it being late next year when the transcripts might be prepared, and then she shifted her tone to claim that she doesn't have to prepare them. It appears she is getting skittish and suspects we are investigating something significant. Also, Shanita is twisting your leg about the timeline. It's completely unreasonable. She can get additional help if she needs it.
I believe that this is what she is referring to. It says that she has to produce transcripts for a litigant, and not for a non-litigant.
If she believes that, she is wrong. B. The court reporter or deputy court reporter shall be paid in advance and shall furnish such transcript within 30 days of payment. This law doesn't say that a non-litigant can't request a transcript. This law does not exclude anyone from making a transcript request. This law simply describes the procedure for what happens when a litigant makes a request for a transcript. The law also doesn't say that a court reporter can deny a non-litigant a transcript if payment is made.
Gotcha. That seems to be specifically for appeal purposes. I'll ask her to justify her statement by reference. I have a hunch that she got this information from someone else, maybe Owsley.
I wouldn't be surprised if she got her information from Owsley. The official reporters appointed under subsection A of this section shall work concurrently under the direction and supervision of the judges appointing them, according to the needs and requirements in the various parishes comprising the district, in the interest of expediting the business before the judges of the court in said judicial district.
If I were Owsley and I got smacked down by the appeals court, I would definitely be paranoid about having the same people digging into my court history. Good. Shanita is cannon fodder for Owsley. It would be good to have a statement from him denying the production of the transcripts. This is why, after I found out that Owsley has to approve all transcript estimates, that I started asking for the document that Owsley has approved the estimate. He can't get away from that.
Feel free to incorporate my references to transparency if you want. Be aware, though, that I'm trying to avoid tipping my hand as much as possible. The court reporter could conceivably alter the transcript. We have no way of getting access to the tapes down the road either to compare to the transcripts. I know a lawyer who litigated this issue recently all the way up to the Louisiana Supreme Court and lost, and he paid $8,000 of his own money to try to get SCOTUS to take a writ on the issue. But they declined to even look at the issue. He's a highly competent lawyer too. The LASC decision on the tapes issue is fucked up in my opinion. We don't want Shanita getting any bright ideas about altering transcripts to insert fake counsel waivers. We are dealing with bad actors here.
Understood. I had the same thought. It would be easy for them to do that.
Yeah, I'm trying to get the transcripts to conclusively prove that Owsley systematically denied defendants the right to counsel at least at the trial stage. With the certified court minutes, I already have a prima facie case. I don't want the Judiciary Commission to sweep this crap under the rug because I have only a prima facie case. I want them to be forced to take action. There are many corrupt and incompetent actors here, and I have to be very strategic about every decision that I make.
This is what makes me interested in seeing if we can propose she outsource the transcript and have a name in mind we can suggest. Then we don't have to worry about alterations, we know what the other person costs, and her excuse for stalling goes away. They can say they don't want to outsource, but then they have to do the work within a reasonable period of time.
The lawyer was William Allen Pesnell, who argued about getting the tapes to compare to what he claimed were doctored transcripts. Pesnell is no moron. He was, Order of the Coif, in law school. I sent you guys a link to a folder with all of his stuff in it. He heard back that SCOTUS declined to take the issue, so he is stuck with the LASC's rotten decision. Judge Hughes would have granted. He's the same and only judge who would have voted to grant in my Sarah Schwartz case involving a jury trial issue. He seems to be the only real civil liberties guy on the LASC.
How useful would more current transcripts be? Fourth cattle call court days where pro se defendants plead guilty to reduced charges?
I think it would all be useful. I was hoping to obtain the worst violations and then perhaps get more information. Yeah, I thought of doing that as a last resort if Shanita won't play nice. If she keeps playing games tomorrow, I'll arrange to have the litigants' phone numbers identified and interviewed to explain to them what is happening and then get them to directly request transcripts.
She did say in her email that a $100 deposit for each transcript, and she never actually said that she wouldn't do it, so that could be done now. The pressing issue then is the timeline for production. She won't change that, I don't believe, unless Owsley orders it.
Maybe request that she appoint a deputy reporter to assist her. I would also cite those provisions I sent you via email about court reporter pooling and such.
The transcript deposits that she is asking for total $1,300.
I presume the total deposit amount of $1,300 is for all of the defendant's transcripts.
Except the Campos ones. She is going to give a separate estimate for those. She said $100 deposit for each transcript.
Okay. Well, at least she now appears willing to do all the transcripts. I wouldn't imagine she would even bother to give us an estimate for the other transcripts if she didn't intend to do them. She can make it easy or hard on herself if she doesn't cooperate with us. One way or another, I intend to get those transcripts.
Just to clarify, on the initial request she replied with the $100 EA deposit and late next year deadline. On the second request for clarification of the timeline, she said that she was not required to provide them and that they would probably not be done. What he could do is to clarify that if the deposits were sent that the transcripts would be done and to have documentation of those estimates and the timeline approved by Owsley.
Yeah, please clarify. Also, include language about being willing to pay for any unexpected costs within the bounds of the law. I don't want her to have any excuses to not do the transcripts.
Shanita, I'd like to get some clarification here. There are 13 transcripts other than the Campos transcripts. At a $100 deposit for each would be $1,300. If I send you $1,300, will you do these transcripts, yes or no? If the answer is yes, please provide this estimate and the timeline approved and signed by Owsley, along with a stated cost per page for the completed transcripts. I understand that there could possibly be unexpected costs that are reasonable and within the law and would certainly be willing to pay those as well. This will remove any confusion. Thank you.
Looks good to me.
No. Those transcripts will not be prepared.
Maybe explicitly ask if she can outsource it.
I think I have to escalate matters at this point. I'm infuriated with Shanita. We could ask the defendants themselves to request copies of their transcripts, but I have a feeling that Shanita would once again stonewall them somehow. I think it's time to play hardball.
If we were to sue the court over not providing records, is that enough for Travis to get Owsley to recuse himself at trial, or would the plaintiff for the records need to be Travis himself?
I believe that she would too. Once she figured that she didn't have to do it, she won't. I have to believe that this is being okayed by Owsley. I can try to get her to have a statement on her denial signed by Owsley.
Well, if I have to wind up suing Judge Owsley and Shanita, that may be grounds for Owsley to recuse himself if I also represent Travis at trial, since Owsley clearly couldn't be fair and impartial towards Travis if I'm representing him, and I'm suing Owsley.
I'm curious to see whether Owsley will hide behind Shanita on this, or will he step up and address this issue himself.
Mail track shows that my email was read 2 times 13 hours after I sent it. No one has responded yet. I imagine they are thinking about what they want to do.
Not even an acknowledgement of receipt. I've asked for those so many times from her and ne've got one. So unprofessional.
Dear Shanita, it has come to my attention that Daniel Bachwist has It has come to my attention that Dan has requested certified transcripts for the It has come to my attention that Dan has requested certified transcripts for the following dates and 5 defendants. Dan is working on my behalf and is working under my supervision. He has reached out to me due to having difficulty in obtaining transcripts. As a result of his difficulty, for the above-named defendants, I am personally requesting certified transcripts of all hearings. 1. And events of whatever type that exist under each of the above-listed case numbers. The information listed above in chart format is based on what we believe exists as far as hearings and case events are concerned for the above-named defendants. If you are aware of any other hearings and events that occurred for the above-named defendants that are in addition to what I have listed, I am requesting certified transcripts of those hearings and events as well. Please check to make sure that the list of hearings for the above-named defendants is exhaustive and complete. In short, I want to make sure that I have certified copies of transcripts for every court-related event in each of the above-named defendants' cases from the pretrial to the trial stages. I am requesting this information as part of an investigation into the inner workings of the Natchitoches City Court. As a Louisiana lawyer and citizen, I have a direct interest in monitoring what our courts do in Louisiana. Transparency is vital to a healthy democracy and effectively functioning judiciary. Obtaining these transcripts allows me to see if the justice system is properly functioning and is fairly treating defendants. Please provide an estimate on the cost of the transcripts requested as well as a reasonable timeline on when you expect to be able to have the transcripts completed. I will gladly pay the expected cost to prepare the hearing transcripts. Should you need additional help in preparing transcripts, I remind you of the following legal provisions involving deputy reporters and court reporter pools that you may utilize to help you prepare the transcripts within a reasonable time frame. There is hereby established a court reporter pool of 30 court reporters employed by the Supreme Court from which said court reporters may be assigned from time to time to any of the various district courts in the state as the need arises in order that transcripts for criminal appeals and other necessary purposes may be timely lodged in the appellate courts. Please advise in writing if you have any questions or concerns. If you refuse to fulfill this request, please state in detail the reason for your refusal and the supporting law for your reason. Be advised that my office will pursue every available legal remedy to obtain these records. Best regards, Phil.
Oh fudge.
I'm done with her nonsense. See below. They need time to think apparently. I imagine they are silently freaking out about being investigated.
Email received. Will respond to letter soon.
I'd love to be a fly on the wall in city court.
See below. I heard back from Shanita. I have asked for additional clarification on her murky response. She is terrible at being clear. Shanita, okay. Thank you for your prompt response. For clarification, when you say, once one is completed, you are referring to all of the hearings for a single defendant at a time, correct? In other words, I can expect approximately 60 days to do all of the transcripts for a single defendant with this timeline repeating itself for each new defendant. I just want to make sure I'm understanding you.
The estimate for Campos trial or hearings already transcribed will be delivered by end of week. Any requests for transcripts not of record will require a $100 deposit per hearing or trial. A 60-day turnaround per transcript. So once one is completed, a new 60-day turnaround begins.
Owsley told her that she has to do them. This is a win. The Campos transcripts will be a good start. My understanding is that once a transcript is filed with the court, it becomes a public record. The recorder can't continue to collect transcription fees on a public record. I wonder if Campos filed a notice of appeal with the city court. How can I find out? What do I ask for? I see. She said that any transcripts not of record, I'll take that to be an acknowledgement that Campos' transcript is our public records. We'll see.
This is definitely encouraging.
See below. Shanita got back to me and clarified her response.
The timeline is per hearing or trial, but that is just an estimate as arraignments are very short and can be included within the time frame.
Wow. See below. Another email from Shanita for even more clarification. They are bending over backwards to mention that the timeline may be shorter according to the workload of the court. I think they are genuinely worried I might sue. They know I'll take them to court if need be. LOL. I interpret this conduct as a win for us.
The timeline may be shorter according to workload of the court. We do not have a full-time court reporter.
She should be able to answer how much per page. Don't trust her to charge what she is supposed to charge.
When you sent the first email to the court, I pictured it as Philip wielding Thor's hammer. The court is clearing, ringing with the impact.
Travis, please do a YouTube video about this recent win for us. Please include my letter that I emailed them. Your viewers need to see that I had to escalate matters to finally get the Natchitoches City Court to agree to turn over the transcripts. I want your viewers to know how ridiculous this whole situation is. We will make our own YouTube record for the whole world to see this situation.